Hi, we are Group 8 from the module Law of Tort 1 under Dr Morgana. I'm Elise, and today me and my group members would like to present our research on the topic of psychiatric injury. Without further ado, let's proceed to our presentation. To start off, what is psychiatric illness? It encompasses all forms of mental conditions that are medically recognized which will bring effects to one's thoughts, mood, behavior, or their everyday lives. Psychiatric illness should be distinguished from intensive fear, emotional distress, or pure sadness, as these experiences alone do not necessarily imply a state of mental illness that may lead to liability unless they result in physical ailments such as heart attack or psychiatric disorder. It is generally possible to seek damages for psychiatric illness, but courts have traditionally been hesitant and exercise caution when granting compensation in such cases. I would also like to introduce on the term nervous shock. It refers to the sudden psychological disturbance suffered by an individual after being involved in or witnessing a traumatic event. It is the potential trigger for the development of psychiatric illness. Next, let me briefly introduce the categories of victims, which will also be further elaborated by my group members later. So victims are classified into two categories, primary and secondary victims. Primary victims refer to those who are directly involved in a pivotal incident, while secondary victims refer to those who do not have a requisite relationship of love and intimacy to the primary victims. These people normally are rescuer, participants, or eyewitnesses in the aftermath of the critical incident. In the case of our court against Chief Constable of South Yorkshire, Lord Oliver emphasized the importance of distinguishing between primary and secondary victims in cases of a nervous shock. So, a primary victim is directly involved in an accident, therefore, is within the foreseeable range of physical injury, while a secondary victim must fulfill the four criteria of Alcott, which are having a close tie of love and affection, proximity to the event or its immediate aftermath, witness the event with their own unaided sense, and the psychiatric injury must be a result of a shocking event. The key distinction lies in the fact that primary victims are more likely to succeed in seeking compensation for psychiatric injury even if the injury was unforeseeable. In contrast, secondary victims not only have to prove that the psychiatric harm suffered must be reasonably foreseeable, he or she must also establish the four criteria in order to recover damages. Moving on, it is crucial to have an understanding of the current medical perspective when discussing the law futures development on negligent-inflicted psychiatric illness. Medical opinions state that a shock may be sufficient to cause psychiatric illness, since the identification of symptoms normally is based on claimant's own report, so in some instances, there will always be suspicions on the severity of a mental injury. Two diagnostic classification systems, American Diagnostic and Statistical Manual of Mental Disorder (DSM-4), was developed for clinical or research purposes, and International Classifications of Diseases and Related Health Problems (ICD-10) categorize known psychological disorder based on the number of criteria symptoms. PTSD, post-traumatic stress disorder. It is the most common diagnosis where nervous shock serves as a triggering factor. One instance that may trigger PTSD is witnessing the death of a family member. Courts have shown notable openness towards acknowledging and considering this phenomenon, potentially influenced by significant disaster like the Hillsborough tragedy. In the case of other mental health conditions like anxiety, neurosis, or depression, the focus is not on identifying the precipitating factors. In such cases, personal weakness plays a more significant role. Hence, establishing a direct connection between the psychiatric conditions with the defendant's negligence becomes considerably more challenging. Therefore, courts must consider the defendant's action in light of the claimant's pre-existing mental health state and determine whether their negligence aggravated or caused harm to the claimant's condition. Alcott against Chief Constable of South Yorkshire 1992 was a case that arose from the Hillsborough football stadium where 96 people died and hundreds more were injured. The claimants in this case were relatives of the deceased and claimed that they experienced PTSD in the aftermath of the tragic incident. Lord Agner's statements reflects on the control mechanism or nervous shock principle. In order for a claimant to receive compensation, there are some elements that the claimants must establish. He held that the psychiatric illness must result from a sufficiently shocking event, rather than a gradual process such as chronic trauma distressing in a hospital. Even if the likelihood of psychiatric illness was reasonably foreseeable, compensations will not be awarded if the injury did not result from a direct contact to the disaster. To sum up, the law barred the recovery of psychiatric illness damages unless the claimant directly experienced the sudden and shocking event or witnessed the traumatic event themselves. With that, I'll pass the presentation to Tiffany to talk about primary victims.
Now, I'll be talking about psychiatric illness in English position. What is primary victim? Primary victim is said to be an individual who has been involved immediately as a participant. Note that a person does not have to actually suffer physical injury to qualify as a primary victim. This situation is in which they are physically endangered, but the only harm is done through the psychiatric route. Case that involved physical injury is Tulio and White 1901. The claimant was a pregnant woman who was behind the bar at the pub when the defendant's servant crashed a coach into the building. The incident sent her into shock, which caused her to give birth prematurely. The child was born disabled due to its premature birth. The claimant sued for damages and the court held in her favor. The court mentioned that the defendant owes a duty not to cause mental injury to people who are reasonably anticipate that they are about to suffer physical harm from the defendant's action. The claimant, which reasonably believe that they are at risk of physical harm, mental harm is assumed non-remote. Kennedy J. states that lesser frights, fear, and general distress are not actionable in negligence. In other words, there must be a recognized psychiatric illness. In this case, the court seemed to classify the premature birth as an injury, referring to the principle in the case of Ya against Medway and HS Foundation Trust. The mother and the child are, until birth, one and the same, and thus the mother can claim herself as a primary victim. In my opinion, I truly agree with the decision decided above, which premature birth was treated as an injury. A pregnant woman should have been given more care as they are prone to get shocked. On a biological level, both the anxiety and fear system in the brain ramp up during pregnancy. The incident that happened just in the blink of eye induced her fear system and sudden hormonal changes. Case where involved no physical harm but psychiatric illness is Page and Smith 1996. The claimant was involved in a car collision caused by the defendant's negligence, but he suffered no physical harm. After the accident, the claimant suffered from chronic fatigue syndrome. The claimant claimed damages for psychiatric illness, but the defendant argued that it is not foreseeable that a person of normal fortitude would suffer that. The claimant's claim succeeded. As claimant was the primary victim, he need not to establish the foreseeability of psychiatric injury, as the physical injury was already reasonably foreseen, even if he did not actually suffer any physical injury. The shell skull rule does apply, which means the defendant must take the plaintiff as he finds him. Judge Orton cited and adopted the reasoning of Malcolm and Broadhurst and held that once it is established that CFS existed and that a relapse or recrudescence could be triggered by the trauma of an accident and that nervous shock was suffered by the plaintiff who was actually involved in the accident, it became a foreseeable consequences. Interesting question asked by Lord Lloyd is that why should it make any difference that the physical illness and the plaintiff undoubtedly suffer as a result of the accident operated through the medium of the mind or of the nervous system without physical injury? Clear example given was that if he had suffered a heart attack, it cannot be doubted that he would have recovered damages for pain and suffering, even if he suffered no broken bones. There would have been no answer that he had a weak heart. He did have the same standing as Judge Orton, which it was unnecessary to ask whether he was under a separate duty of care not to cause foreseeable psychiatric injury in the case of primary victim. Other speeches were that Lord Lloyd and Lord Browning Wilkinson thought that in the car accident case such as this, physical and psychiatric illness are both foreseeable. A person of normal fortitude could have well been terrified. To sum up, this case laid down the legal consequences of the distinction as followings. The first one, different remoteness of test does apply in different class of victim. For primary victim, defendant is under a duty not to cause foreseeable physical injury. Once it is established that the defendant owes a duty of care not to cause personal injury to the plaintiff, it matters not whether the injury in fact sustained is physical, psychiatric, or both. It could not be a right way that a negligent defendant should escape liability for psychiatric injury just because though serious physical injury was foreseeable, it did not in fact transpire. For secondary victim, foreseeability of psychiatric injury is a crucial ingredient that need to be proven by the plaintiff since he is almost always outside of the area of physical impact and thus it's not foreseeable that he will suffer physical harm. The second one is the criteria of the liability applicable to secondary victim is inapplicable to primary victim. Proximity of the relationship cannot arise and proximity in time and space goes without saying. Primary victim can only be the one who suffered physical harm or endangered to be harmed. The third one is the injury must be a recognized psychiatric illness. Fear and general distress did not take into account. Another example is Young and Charles Church, Southern Limited 1997. A good example of the expansionary effect of Page is provided in this case. A workmate of the claimant had been electrocuted after the scaffolding pole he was carrying came into contact with an overhead electricity cable. He saw that his workmate had been killed. The claimant sued his employers for the psychiatric illness that resulted. The employers admitted their negligence in not ensuring the safety, but denied that they owe the duty of care towards the plaintiff. Lord Ewan held that the claimant was a primary victim applying Page because it was in the area of physical risk created by his employer's negligence, while Lord Harthorst accepting defendant's appeal, classifying the claimant as a secondary victim on the grounds that his injury was brought about by the infliction of a physical injury upon another person. However, both agreed that in the case, the foreseeable risk of physical injury was determinative and no valid distinction with Page. The claimant foreseeably endangered by the defendant's breach of duty is a primary victim However, the commentators have pointed out that in some circumstances, the area of foreseeable physical risk created by the defendant's breach of duty could be very extensive, result that the primary victim aspect of page may undermine the Alcott restriction on secondary victim. This condition happened when the time gap between the negligence and the incident is longer. Many more people could come within the area of foreseeable physical risk. Trinidad gave the example of a disabled aircraft which flies over a city and crashed into a residential building. Page approach seems to lead to a result which almost any resident in the city that suffered shock counted as a primary victim. A question given was that if a train was derailed through a driver negligence, are all the passengers primary victim or only those in derailed carriage? My answer is the former. Note that the derailed train can forcibly cause physical and psychiatric injury. Since the forcibility is proven, thus the defendant also has duty of care regardless the type of harm suffered by the passengers in the train. I will pass the presentation to Singing.
So I'll be continuing on the secondary victims. In the case of Alcott against Chief Constable of South Yorkshire 1992, the Hillborough tragedy was the focal point of this case. Since none of the claimants were in the area of greatest risk at the time, they cannot be considered as the primary victims. These were all passive and unwilling witnesses sharing close relationships with the immediate victims who died. It was held by the court that for a duty to be owed to protect a secondary victim from psychiatric harm, the three elements in McLaughlin and the claimant must have suffered harm by way of sudden shock as a result must be met. They were applied and were not met in each of the claims. Obviously, those who watched the Hillborough disaster pictures and knew they have loved one on the ground would undoubtedly feel extreme worry. However, the shock wouldn't have occurred until they were told that their loved one had actually been killed or injured. Instead of the pictures, it was hearing it from a third person that actually shocked them. The fundamental essence is that the element of shock must come from the immediate communication. After this case, considerable importance was attached to whether the claimant was a primary or secondary victim. Primary victims do not have to worry about the duty in law question. The law gives no damages if the psychiatric injury was not induced by shock. Shock, in the context of this cause of action, involves the sudden appreciation by sight or sound of a horrifying event, which violently agitates the mind. What is necessary to establish responsibility is something extraordinary in nature. This means there can be no claim for depression caused by looking after a victim injured by someone else's negligence. One justification of the requirement might be that in cases where there is an element of shock, the causal connection between the negligence and the psychiatric injury is likely to be clear. Whereas in long-term care cases, there could be other things causing or contributing to a claimant's depression. It has also been stated that the word nervous shock gives the judge freedom, which is an important aspect of their position. According to Lord Agner, the cases from the past century demonstrate that the scope of liability for shock-induced psychiatric injury has significantly increased. It demonstrates that it is a claim in a distinct category and a separate kind of injury. Whatever the trend of future legal evolution in this field may be, the aforementioned principles show that the straightforward application of the reasonable foresight test is far from being helpful or conclusive. To sum up, McLaughlin and Alcott case established that secondary victims could only claim psychiatric injury in very limited circumstances, and the White case, which will be discussed further later, confirms these limitations. On the part of rescuer may suffer psychiatric injury after helping at an accident caused by negligence. If endangered themselves, they could be categorized as primary victim. In the case of Chadwick against British Railways Board 1967, after helping in a terrible train accident brought on by the defendant's carelessness, which resulted in 90 individuals' deaths and others suffering severe injuries, the claimant had suffered psychiatric injury. He stayed at the scene all night, and as a result of his experience, he sustained serious psychiatric injury, unable to work, and developed an anxiety neurosis. The court held that because the claimant put himself in risk while engaging as a rescuer, the defendant owed him a duty of care. Obviously, the court wanted to demonstrate its support for those who wanted to help at an accident scene so that future rescuers wouldn't be discouraged from helping. And next, in the case of McFarlane against E.E. Caledonia 1994, the claimant was on a ship that aided an oil rig that was in fire. The entire time the fire was being put out, he stayed on a vessel 100 meters away. He sued the owner of the oil rig for negligence, claiming that seeing the deaths and injuries that the fire had caused have left him with psychiatric injury. He was deemed to be a bystander rather than a rescuer by the Court of Appeal. Since he was neither a primary nor a secondary victim, the defendant owed him no duty of care. And lastly, in the case of White against Chief Constable of South Yorkshire 1999, in Alcock it appeared that the House of Lords favoured a broad definition of rescuers. However, in this case, they decided that only rescuers who put themselves in risk during the rescue or who had a good basis think that they were doing so could bring a claim. The police officers in this case sued their employer for PTSD from the aftermath of the Hillsborough disaster. Although they were never in danger physically, the claimant contended that their role as a rescuer exempted them from the restrictions in Alcock and allowed them to recover since the risk of psychiatric injury was reasonably foreseeable. Their claim failed. The House of Lords held that they were not primary victims. The legal principle in this case is that a claimant who experiences psychiatric injury but is not physically harmed or in danger of doing so is a secondary victim who must satisfy the Alcock test. In summary, in order to be entitled to damages for psychiatric injury caused by negligence, the rescuer had to physically endanger or reasonably believe that they were, only if that he might become the primary victim. The presentation will then be passed on to Charmaine, who will be focusing on the Malaysian position.
I'm Charmaine, and I'll be talking about psychiatric illness in the Malaysian position. So, I'll be first talking about earlier cases of psychiatric illness in Malaysia. The case I'll be referring to is Zainab binti Ismail against Mari Mudu and another. So, the facts of this case are, the plaintiff's daughter was killed while washing clothes at a standpipe in Lorong Merpati by a lorry belonging to the second defendant and driven by the first defendant. The first defendant, a lorry driver, drove the lorry belonging to second defendant along a quiet street at a high speed, recklessly and noisily. As a result of his negligent driving, which was true, the plaintiff's daughter was killed. The evidence showed that the plaintiff actually saw the accident, as a result of which she suffered from the shock and was still sick nearly after 2 years of the accident. The plaintiff claimed damages for shock and illness arising out of negligence of the first defendant. I think it is worth repeating here a part of Section 964 from the Current Law Yearbook 1953. The shock of mother seeing accident to child. The test of liability for shock is foreseeability by injury by shock, but this test is by no means easy to apply. This test is not what the negligent party himself could reasonably have foreseen, for he rarely has time to foresee anything. The test is what a hypothetical reasonable observer could reasonably have foreseen. It is difficult to decide where the line is to be drawn. As Lord Wright observed in Bohill against Young, which says psychiatric injury to a bystander who is unrelated to the primary victim is generally unforeseeable. The line is to be drawn only where, in the particular case, the good sense of the judge decides. Also, as said by Lord Denning, the true principle as I see it is this. Every driver can and should foresee that if he drives negligently, he may injure somebody in the vicinity in some way or another, and he must be responsible for all the injuries which he does in fact cause by his negligence to anyone in the vicinity, whether they are wounds or shock, unless they are too remote in law to be recovered. If he does by negligence in fact cause injury by shock, then he should be liable for it unless he is extant on the ground of remoteness. So, the decision of court on this case is, the court applying the test of what a hypothetical reasonable observer could have reasonably have foreseen to the fact of this case came to the conclusion that the first defendant cannot be exempt from liability for shock to the plaintiff on the ground of remoteness. The plaintiff is therefore entitled to recover damages under this head. The doctor evidence showed that the plaintiff is genuinely suffering from shock, and she appeared to be still in a sick state nearly 2 years after the accident. In conclusion, the court allowed the plaintiff claim for nervous shock sustained a result of seeing her daughter knocked down by the defendant's lorry. As Street observed, case law on psychiatric harm or illness mostly concerns post-traumatic stress disorder, PTSD. The mental anguish must be of a kind which is mentally recognized and is echoed under the case Tiru Fanomali against Diners Club. The fact of this case is, the plaintiff, a medical doctor, was a member of the Diners Club credit card. Due to a mistake on the part of the defendant, a condolence letter was sent to the plaintiff's wife informing her of his death. The employees of the defendant mistakenly changed the status of the plaintiff to the account of a Diners Club member who had passed away, which was supposedly done on another account. The defendant only realized its mistake in sending the condolence letter after the plaintiff contacted the defendant by phone. The defendant apologized for the said mistake, but the plaintiff was not satisfied and filed an action against the defendant for damages as a result of shock, fear, and mental anguish for himself and also his wife and children. The court denied his claim even though it acknowledged the plaintiff's discomfort and even anger at the misinformation about his death. Ordinary emotions of anxiety are not recoverable. Moving on to the decision of court, it was held in this action the plaintiff made 2 claims for damages, which was for himself and for his wife and children. The plaintiff has no locus standi, the right to be heard or seen in court, to claim damages on behalf of his wife and children, whom it alleged as having suffered shock and mental anguish. The wife and children were not parties to this action. This can be related to the Alcock criteria, which states that proximity to the event itself or its immediate aftermath must be demonstrated by secondary victims in order to establish liability. From the statement of claim, it was clear that the plaintiff did not have a reasonable cause of action as what he alleged to have suffered from shock, fear, and mental anguish. It was feelings of the plaintiff that he was uneasy or angry with the said condolence letter as he was still alive. The plaintiff as a doctor had wide experience in overcoming situations worse than what was as stated in the condolence letter. There may have been a feeling of anger and dissatisfaction felt by the plaintiff, but it was not an actionable thought that could be compensated by damages. Moving on, I'll be talking about the case in relation with the English position case, as stated, is alcohol. In the plaintiff pleading, it is not stated that they experienced nervous shock resulting in psychiatric illness. What is stated that is they experienced shock and mental anguish. Therefore, the defendant is not liable. The principle of law is further enforced by House of Lords in the case of alcohol, which is cited as the following. Even where the nervous shock and subsequent psychiatric illness caused by it could both have been reasonably foreseen, it has been generally accepted that the damages for merely being informed of, or reading, or hearing about the accident are not recoverable. A psychiatric illness induced by mere knowledge of the distressing fact is not compensable. Perception by the plaintiff of the distressing phenomenon is essential. Mere mental suffering, although reasonably foreseeable, if unaccompanied by physical injury, is not a basis for claim for damages. It is clear from well-established principles of law that there is no liability on anger feeling, fear, mental stress, anxiety, and others experienced by the plaintiff unless it is a physical injury. The shock, fear, and mental anguish experienced by the plaintiff was clearly not a cause of action against the defendant. Next, I'll be passing it on to Wen Xingrong to make a conclusion.
I'm going to talk about policy consideration and conclusion. As discussed above, no difficult to find out that the area for psychiatric illness becomes broader and covers many more aspects as the time goes on. Thus, policy consideration has been established to limit the unnecessary claimant and to smarter litigation procedures. First and foremost, to avoid the opening of floodgates, the floodgates argument is probably based on the fear of proliferation and of claims from a single event. Our tutor fear of many claims from various events such as proliferation or at the court system and diverse to many society resources to considering the victim of psychiatric illness as the expense of the many who presently receive little or low compensation. Therefore, physical injury serves as a result of negligence. Last, to avoid fraudulent and exaggerate claims, in particular, the danger of exaggerate claims has been described as the only real problem that leverage occurs for the cause. More specifically, first, that claimants can relatively easily pick the center of the psychiatric illness, and secondly, that even if the cause may not be taken by regular and exaggerate claimants, it may not be easily to challenge such claims without court, so that out of court judgments will be hampered. However, the plaintiff is now required to establish or recognize psychiatric illness wherein itself provide a deterrent to several claims and some deterrent for quite popular claims. Moving forward, conflicting medical opinions lead the court to make a strict decision in the case of psychiatric illness. A consensus of sorts among professionals working in the field is now clear from the psychiatric and psychological literature as a result of significant research into the performance of traumatic stress response and PTSD in particular. However, there may legitimately be difference between several medical professionals regarding both the kind and severity of the plaintiff's particular mental condition. When the court chooses which medical opinion to rely on and whether to ground the canon of law problem arise. Furthermore, what the truly reason for the court's restrictive approach to claims for psychiatric illness is that injury to the mind is less worth of community and legal support than physical injury to the body. Even while such harm cannot be the naked eye, it nonetheless exists, and the psychological aspects of trauma are more severe and deserving of legal attention than the one that are. Last but not least, is some reluctance about compensating such secondary victims that support the limited approach to check into psychiatric illness. It is still necessary to prove that the defendant owns the plaintiff a direct responsibility in our secondary victim case, and it is possible that the tighter opposition is motivated by concern of opening the floodgates of litigation. In conclusion, we have examined cases involving the negligent infliction of psychiatric illness, in which the duty of care rules are complex, while primary victim of negligence who serve psychiatric illness are fraud, while the duty of care, recovery, and secondary victim are restricted to those who the court believed can claim who damage due to the horror of events they are caught in. Although the rule seeking for compensation is said to be harsh, it should not be a reason that stops a genuine claim from claiming psychiatric injury. As that it doesn't be speaking well of legal system where law, even legal advice and trial judge know with some degree of certainty that is required by the law, and the only time the litigant can be sure is when apply court makes the determination.